welcome the REC members once more to the meeting number 392 held today, the 24th of February 2025 via Microsoft Team. And also welcome members of management and support staff who have joined us for this particular meeting, and as well as our stakeholders who have joined us for the meeting. And I must convey my apologies on behalf of the committee for the late starting of our meeting. It was not intentional. There were things that we had to discuss prior to the set starting time in terms of the adverts that have been shared with you. On that note, before we really proceed with the business of our meeting, let me start by introducing the members of the REC for the benefit of those that have not heard them speaking or those that do not know them. I would like to introduce the first member of the REC committee, Ms. Maseti, who is the member of the REC and as well as the chairperson of the Pipe Gas Subcommittee and Electricity Subcommittee. And she is also a member of the other committees set by the Energy Regulator. Ms. Maseti, over to you. Can you greet everyone?
Good morning, Chairperson. Good morning, Mr. Mkhize, and good morning to the members of the public observing today's proceedings. Thank you very much.
Thank you, Ms. Maseti. I will then move on to the next member, Mr. Mkhize, who is the member of this particular committee and as well as the chair of the Petroleum Pipelines Committee and a member of other subcommittees of the Energy Regulator and committees. Mr. Mkhize, over to you.
Thanks, Chairperson. Good morning to all and sundry. Thank you.
Thank you, Mr. Mkhize, and may I also indicate to everyone in attendance that this particular meeting is recorded via MS Team. On that note, members, we do have an agenda that was publicized to members of the public, and in terms of the agenda that has been advertised, we've got about 7 items that are for the open session. And once we have done that, we will then have our meeting close and proceed with other items that are going to be discussed in the closed session. Members, with that agenda for the open session, can I get an indication that you do support the adoption of the agenda as presented by show of hand? Thank you, Mr. Mkhize. Thank you, Ms. Maseti. And I also do support the adoption of the agenda for the open session. We proceed. Apologies. We proceed to the first item, which is item 5, reasons for decision on municipal and private distributor tariff application for the 2024-25 financial year. Mr. Mkhize Jr., if you can guide us as to who's going to lead the committee on this particular submission. Over to you, Bob.
Thank you, Chairperson. Ms. Maria Matlaho will lead on this one, Chairperson. Thank you.
Thank you. Over to you, Ms. Matlako.
Thank you. Thank you, Chairperson, and good morning to members and colleagues. The submission that we have in front of us is an RFD on the municipal and private distributor tariff application for the financial year 2024-25. The RFD covers the legal mandate that the regulator has to regulate tariffs and prices, including those of municipalities, which must be approved for implementation, or which must be implemented on the 1st of July for each year. It covers the process which the regulator followed to approve the 178 tariff applications which was submitted. It also covers the approach which NERSA took to consider the applications, which considers the actual costs that licensees incurred in supplying and operating its distribution facility. The RFD also covers or details the public participation process, which was followed in approving these tariff applications, the comments received and analyzed. We've included, Chair, as part of the RFD, 3 annexures. The first annexure, it's one listing all the tariff applications for all the 178 licensees that submitted tariff applications. Annexure 2 covers the actual tariff analysis sheets for all the 178 licensees. And the last annexure covers comments received from stakeholders which were analyzed, and the analysis then forms part of each analysis sheet for each of those municipalities and private distributors that submitted applications. The recommendation, Chair, is to request REC to approve the RFD for the municipal and private distributor tariff for the 2024-25 financial year. Thank you, Chairperson.
Thank you, Ms. Matlako. Members, any questions, issues of clarity or points of enhancements for the team on these particular RFD? If you have any, kindly raise your hand. I'll recognize you. Over to you, members. Ms. Masetti, then Mr. Mkiza after you. Over to you, ma'am.
Chairperson, I don't have questions as I have had discussion with the team. The only 2 things that I would like that we make sure that we the team will protect confidential information. As we have dealt with cost information that is sensitive commercial information that belongs to the municipalities, individual municipalities, just to make sure that as we take the decision and those parts of the information that is commercially sensitive and needs to be protected by the energy regulator, that it be protected. I just wanted to emphasize that, and also just to make sure that, as we indicated, information that is specific and comments that are specific to an individual municipality must appear on that municipality, even though there is a part that pertains to consolidation of these matters, since they deal with substantially the same aspects, but there are differences. So it must be important that those differences at least are assigned to the relevant municipality. Just to indicate that, Chairperson, and it is something that I also emphasized with the team. Thank you.
Thank you very much, Ms. Masetti. Babu Mkiza, Senior.
Thanks, Chairperson. Noting that we have commented on this before, I think from my side, just the improvement on especially paragraph 4, we know that the delays were due to challenges. There's been a hive of activity for the department and division, noting also the work that we from the team, from our side, had also requested the team to put more focus on the MIPD 6 application, as well as the tariff, the retail tariff plan changes. Those are some of the things that the team has had to kind of put its focus on, and I think that whole section need to be reworked in view of being able to project the right picture as to what actually transpired. I'll leave it at that. Thank you.
Thank you, Mr. Mkhize. I also support that reworking of paragraph 4 that we have actually discussed earlier on, to say that the team needs to look into it. I do not have any other additional comments other than that. That which has been said by members. I would then request members that we go to the recommendations if there are no other inputs from members. If not, members, the recommendations are on paragraph. I'm just trying to get there. They are on paragraph 14 on page 7. And the recommendations are that the REC is recommended to approve the reasons for decision on municipal and private distributor tariff application for the financial year of 2024-25. Members, by show of hand, can I get an indication that you support these recommendations subject to those enhancements that members have raised? I see the hand from Ms. Masetti supporting the recommendation. I do support Mr. Mkhize. I'm not sure whether you're struggling with raising your hand. If you are, please just indicate to us verbally by opening your mic. Mr. Mkhize?
Yeah, I support and the noting also by ER. I think it will be in order. Thank you.
Thank you very much. Thank you very much for the support of the recommendations. On that note, we move on to our next item that is on our agenda under the electricity regulation industry. And that report is item 6, which is the quarterly report on registration of generation facilities approved in the third quarter of 2024-25. On that note, Bobo Mkhize Jr., can you kindly assist us in considering the item? Thank you.
Yes, thank you, Chairperson. This item will be we will be assisted by Mr. Elvis Matikwane, assisted by Sanele Zulu. Thank you, Chairperson. Over to you, colleagues. Chairperson, yeah. Okay, carry on.
Okay, thanks, Mr. Mkhize. Good morning, Chairperson, members of the public and the colleagues. Taking the matters read, the purpose of the submission is to request the REC to know the quarterly report on registered generation facilities approved in the third quarter of 2024-25 financial year in terms of the standing instruction number 9 of the electricity subcommittee delegation matrix. The REC is duly delegated to know the report on registered generation facilities. On background, since the inception of the registration regime, NERSA has registered about 1,811 generation facilities. This is shown on table 2 on page 3 of 12, with a total capacity of 10,550 megawatts. For deliberations, is that during the third quarter of this financial year, we have registered about 143 generation facilities with a total capacity of 1,107 megawatts. And this is shown on table 3, also with different technology per province. It should also be noted that the average days taken to process the applications has been 14 days. Recommendations are on page 6 of 12 under paragraph 14, which is that the REC is to know the quarterly report on the registered generation facilities approved in the third quarter of the current financial year in terms of the standing instruction number 9 of the electricity subcommittee delegation matrix. Thank you, Chairperson.
Thank you very much. Members, any comments, issues of enhancements, or any matter that you may have picked up from the submission? Please do raise your hand. I'll recognize it. I see Ms. Masetti's hand is up. You may come in, ma'am.
Thank you, Chairperson, for the opportunity. Chairperson, the only reason that I raise my hand, it is to really emphasize the good progress that has been made by the energy regulator in processing these registrations and the improvement in terms of the turnaround times. As you have heard, that the energy regulator has significantly improved the efficiencies around the registrations. It is 14 days, and if you for 14 days for the quarter that has been specified, and also the amount of the capacity that has been registered. It's important that these things come out there, that our communication improve the way in which it writes up the media statements and indicating the impact and the interventions of the regulator in allowing additional capacity from the cleaner energy that has been registered by the energy regulator. And I'm hoping that after the meeting, we would have some proactiveness from the communications department to make sure that the good work that has been done, it is well profiled by the energy regulator, and so that stakeholders can be in a position to see what has been done and how the energy regulator has facilitated these investments in the shortest space of time, and by doing so, adding such substantial capacity to come on stream, as long as the owners will be able to commission the projects that we have registered. So I just wanted to emphasize that, and I'm hoping that we'll have a better way of articulating some of these good work that has been done by the energy regulator, rather than at least this be done by people outside who are able to articulate it better than we do. Thank you.
Thank you very much, Ms. Maseti. Babu Mkiza.
Thanks, Chairperson. Apologies for the delay in talking. There's a technical challenge here. But I would like to say that, first of all, also echo the same sentiment by my colleague around the issue of improved efficiency and effectiveness in dealing with this matter, noting that there was also not necessarily a delegation, but an instruction by the ER to the member primary responsible, so that this can be, the approval of these registration can be expedited. I would also like to get a reflection from the team around the issues of capacity, noting also, if you look at the table 2, where you see the increases of these generation facilities, on an annual basis, right? As to what that implies in terms of capacity, if any. 2, I would also like to get an understanding of the commissioning of these facilities, not just to look at when they got registered, but when they also got commissioned and are operational, so you can always have a good picture. And also to mind issues of regulatory information requirements from registrants, so that we can have a good sight as to what is happening in the industry, apart from the big players, to also include these embedded generation facilities. Thank you.
Mr. Mkiza and Ms. Maseti, for your contribution. I just have one enhancement. I think maybe in the table 2 on paragraph 4.6, maybe we can just do as we have done with the other tables 3 and 4 and indicate the total, because I do note that the total is mentioned as a sentence above that particular table. Maybe let's just add in that table the actual total of 181 and the total of megawatts, and just for completeness, because at times we have to report through the communications department these numbers, so it will be easy for them to really extract them in a tabular form without really having to wait for the division to give them the proper table. So that will just assist in being speedy in responding when these requests are made. On that note, Babu Mkize and the team, I'll hand over to you to respond to members' points that they have raised. Over to you, Babu Mkize Jr.
Thank you, Chairperson. I will just touch on the question raised by Mr. Mkize in terms of capacity in Table 2. What are the implications of the connection of these embedded generators in terms of available capacity? Chairperson, these are approved based on the availability of capacity. So where capacity is not available, these cannot be approved until the network has been enhanced in order to be able to accommodate the new connection. The others, Chairperson, we take them as matters of enhancement, but the HODs here, if there's anything HOD that you would like to add, the floor is yours. Thank you.
Okay, thank you. I think you've covered it all. There's nothing to add from my side.
Thank you, Chairperson.
Thank you, Team ELR. Members, any follow-up questions that you may have for the team? If there is none, I
just want to say there's capacity in terms of the network and also capacity internally. If that, do these have a bearing on the capacity internally with the increases that we see coming?
Okay, thanks.
Just to verify that if there's any need, just to confirm.
Mkize Junior, if you can clarify that if you can add in terms of the clarification sought by Mr. Mkize in terms of capacity internally and externally. Over to you.
No, thank you, Chairperson, and thank you, Mr. Mkize, for that clarity. Mr. Mkize, there is always a need for more hands, but we are currently managing. As you can see, the turnaround times are improving. So I would say in the meantime, we are managing, but in future, when these applications start to really increase, we might need to look at adding more staff to assist, especially with the changes in the industry and the market that is envisaged to start operating by April next year. But thank you for the comment, Mr. Mkize.
Okay, thank you. Mr. Mkize, are you okay with that? We'll get more information.
Thank you.
Thank you. Thank you, sir. There. On that note, members, we go on to the recommendations. The recommendations are on PA6, paragraph 14, and the recommendations are that the REC notes the quarterly report of unregistered generation facilities that have been approved in the third quarter of 2024-25 financial year in terms of the instruction note number 9 of the electricity delegation matrix. By show of hand, members, can I get an indication that you support the recommendations to note? Thanks, Ms. Masetti. Thanks, Mr. Mkize. I also do support. The submission is noted accordingly, Babu Mkize Jr. We then move on to the open session items that are for the regulation of the petroleum pipelines industry. The first one is on the BP Southern Africa's application for the revocation of a license issued for the operation of a petroleum storage facility located at the Plettenberg Bay Airport in the Western Cape province. Ms. Mtwa, please assist in leading the committee on this particular item, or direct us as to who is going to lead this particular presentation to the committee. Over to you.
Thank you, Chairperson. Good morning, members. Good morning, colleagues and members of the public. For this revocation application, may I introduce Mr. Toto Ndawana, who is our learner, who was working under the supervision of Ms. Ngobeni, who has requested that he get his opportunity to present to the committee. Over to you, Mr. Ndawana.
Thank you, ma'am, for the introduction. Could I please ask if I'm audible or not?
Can hear you. Please proceed.
We can hear you, Mr. Ndawana. Over.
Okay, thank you, Chair. Good morning, Chair, to the members, the external stakeholders and colleagues. The submission is taken as read, but highlighting the following aspects shortly. BPSA initially applied in terms of Section 24(1)(c) of the Act, which states that the authority may revoke a license on the application of a licensee if another person is willing and able to assume the rights and obligations of the licensee concerned. The facility under consideration was sold to Chem Air. However, following the transaction, there were certain developments relating to the airport owned and operated by the municipality where the tanks are located. Therefore, Chem Air, which is the only flight operator doing commercial flights there, was unwilling to continue to sign the undertaking to assume the rights and obligations of BPSA as was previously agreed. The South African Civil Aviation Authority deemed the runway unsafe for Chem Air to use. The municipality's plans and timelines to repair, recertification, and reopening of the airport and negotiations to reinstate commercial flights are not known and external to Chem Air's control. However, the facility is currently non-operational due to the aforementioned safety issue, and that the Plettenberg Bay Airport is no longer able to operate commercial flights. The transaction was completed and the transfer of assets from BPSA took place. BPSA wants to finalize its divestment for the aviation sector. This prompted BPSA to then apply using Section 24(1)(a), which states that the authority may revoke a license on the application of a licensee if the licensed facility or activity is no longer required, as per the advice of NESA personnel. In terms of the market considerations, 60 meters cubed of fuel storage capacity will be removed from the market until safety issues are addressed and the airport is operational again. In terms of the environmental considerations, no significant risk to the environment was identified in the risk assessment conducted by an accredited environmental practitioner, and therefore no further mitigation measures were deemed necessary. It is therefore recommended that the REC consider and approve as per paragraph 14 of page 5 of the cover submission. Firstly, the revocation of the license issued to BP Southern Africa Pty Ltd for the operation of a petroleum storage facility located at Plettenberg Bay Airport. And secondly, the decision and reasons for decision document attached here to as Annexure 1. Thank you, Chair.
Thank you very much, Mr. Ndawana. Members, there is the presentation from one of our learners, and can we then raise any questions and issues of clarity or points of enhancements in terms of what he has presented? Over to you, members. Thank you. I see a hand from Ms. Maseti. You may come in, ma'am.
Thank you, Chairperson. Just one question from my side. That is aspect of compliance with, is it Regulation 11? I'm not sure about the regulation number. but it relates to rehabilitation of land to the extent that there was allowance for decommissioning of the facility. So as it is required in our legislation that land rehabilitation be part of our regulatory oversight, and so that in the tariff we make sure that there is an allowance that is put aside, so that if there is going to be such if when there is reformation, we have to make sure that the issue of land rehabilitation gets taken care of. So I would like to find out about compliance with that before we take a decision for revocation, if I can be clarified on that. Thank you.
Okay, thank you, Mr. Mkiza.
From my side, just a comment, Chairperson. We note that when it comes to these airports, the multinationals have been moving out, so to say, and then being taken over by AXA in all of them. Though they are small, they play a strategic role when it comes to interface of South Africa with the world, as well as just the transport side of things, in terms of refueling of aeroplanes, and they don't pose a challenge, particularly when it comes to the environmental aspect that much, looking at their sizes in general. But I'm just raising this to say, members, just to say this, note that aspect. And I think it's important for the team just to know that aspect, that this is now a trend that we have observed. And you note, I think there's still one or two that will be coming our way still. Thank you.
Thank you, Mr. Mkiza. That is noted. And maybe if we could ensure that is also covered in the submission cover and RFDs, so that members do not get to raise it in the meeting. On that note, Ms. Mtwa or Mr. Ndawana, do any response in terms of the clarity sought by Ms. Maseti in terms of compliance with the rehabilitation processes of land before consideration of of this revocation application? If you can just come in on that, so that we provide that particular clarity. I see that they wanted to sign this up. You may come in, Martin.
Good morning, Chair, members and members of the public. I think, as Ms. Maseti indicated, that is what the requirement of the Act is, that should be checked, and that there's no liabilities transferred to the new parties. In terms of that, the report, as we've indicated in the submission, there was accredited a service provider that did an assessment, and there was no risks identified of any potential rehabilitation need. However, I'll also have to just ask Ms. Buku or the team from PPT to just assist me, but BP there has been engagement with BP in terms of their mechanism, in terms of all the various airports that they have, but I will need assistance from our PPT colleagues just in terms of the actual detail.
Thanks, Mr. Untit. Ms. Boko.
Thanks, Mr. Untit. Thanks, Chair. Chairperson would like to confirm that BP does not yet have an approved instrument for accumulation of rehabilitation funds. Therefore, there were no funds recouped through tariffs. If there were funds recouped through tariffs, we would have to also monitor the transfer of such funds to an instrument that is to be acquired by the new party. However, in this case, the liability was just sitting in BP's financial statements, that is the balance sheet. So we won't have to do that exercise of monitoring in this case. We would also like to inform the committee that we are currently in the process of enforcing compliance on this front with BP, and soon they will be submitting their proposal for a financial instrument. Thanks, Chair.
Thank you, Ms. Boko. And Ms. Masetti, I will assume you have a follow-up question on this on these responses we received from the team. Anything from your side?
Thanks, Chairperson. I think Martin has touched on it to emphasize that it is a requirement from our side. We have to make sure that we execute our regulatory functions properly and make sure that there is compliance with the regulations. So in this case, we have not done it, and now we get to a point where there is revocation on this of this facility. So it becomes a problem, because now what then happens with that intention that was always there, that when there is a facility and infrastructure that has been operated that may even have some safety issues, and then now it needs to be monitored at the time when that facility is no longer going to be used. And it is even worse in this case, because there is safety concerns that are being raised here. So where we have not done what we are supposed to do, it does become a problem. And I'm hoping that the team will not wait until we get to this point of revocation, that with all of the licensees that are operating infrastructure, petroleum infrastructure, that we will make sure that they comply with the requirements of the law of our regulatory framework. All I say at this point, Chairperson, but it is something that we have mentioned this before, that they need to make sure that they put out there even a notice if they can. They can put out a notice calling all of the licensees to make sure that they comply with that the regulations for rehabilitation of land, and give them time within which they need to comply. And if they fail to then comply, then they indicate that the energy regulator will have no choice but to then issue notices of non-compliance, and even move on to a stage of sitting as a tribunal to impose an administrative fine if they are not complying. I think we need to move into that space now from the compliance point of view, and so that we can enforce these things. Thank you, Chair.
Thank you, Ms. Masetti. Noted. I see Martin's hand is up, and I was just going to also add to say that if there is this application for revocation and there was no submission by BP on how to deal with rehabilitation of this particular facility, how do we then deal with it? If there's a new interested party to take over the facility, how should that particular entity deal with some of the issues that are coming out of what has been revoked by BPSA that relates to what should have been done under the rehabilitation? I'm just hoping that, Martin, in your response, you'll also cover my point. Over to you, Martin.
Thank you, Chair. We duly note the comment from Ms. Masetti in the committee, but then also touching on your concern, Chair. So I just need to make it clear, the safety concerns is about the runway, and it's a Civil Aviation Authority ruling. So there's never been a question in terms of the safety of the facility, which is located on the airport. The problem is the airport runway has been declared unsafe. And I think I just wanted to put that on record. Then secondly, we've had 2 meetings with both the new interested party as well as BP. in terms of discussing that, there was a due diligence done as part of the transaction. The report from the competent authority is clear that there's no rehabilitation needed at that facility. So in terms of that risk, it was dealt with. It's not like we haven't dealt it, but we do note the maybe the stricter way of, or positive way of doing it as suggested. And then thirdly, it was discussed in terms of the tariff. So this facility was only used by BP during each operation term. So there wasn't a tariff which could be. There was a tariff, and approved, but I mean, they didn't recover anything at that point. But I think we have heard and what we are doing in terms of enforcing the compliance. I trust this gives the members some comfort, and that I've answered both of your questions.
Thanks, Martin. Ms. Maseti, any follow-up? I think from my side, Martin.
No follow-up, Chairperson, but we must not share. Oh, sorry.
Proceed, ma'am.
What I wanted to say is that, thank you. What I wanted to say is that let us not minimize the legal requirement. Our requirements are very clear. We must make sure that licensees comply with rehabilitation of land. This is, and we must make sure that by the time that we get to revocation of the license, that we know exactly what's going to happen with the facilities that were being operated, and we were having the powers to monitor that they should be the land that was used for the operation of those facilities. It is left in a position that is acceptable, and that there will be things that will be done to rehabilitate that land. That is important. It is our duty. And I recall that even in 2015, 2016, there was an issue where the revocation decision delayed because of the fact that there was an issue with lack of compliance with rehabilitation of land. And the team that is here, including Martin as well as Ms. Boko, they know that very well. And it was an issue even at that stage. And I'm surprised that even today we are talking about the same thing as opposed to enforcing compliance. That's what I want to say, because it is on record. It was in the PPS at that stage in 2015, 2016 financial year. And to date, we're still talking about the same thing and the delay that was there for taking a decision on revocation. Thank you very much.
Thank you, Ms. Maseti. Mr. Mkhize, you may come in. Ms. Boko, I see your hand, but I wanted to allow the member to. Okay, come in, Mr. Mkhize.
Can you now hear me? Can you hear me?
Yes, we can hear you. I think you had a delayed process in unmuting yourself, but you may come in, sir. We can hear you now. Or I can personally hear you. Over to you.
Yeah, I'm just a bit confused here by how the team is responding, because if you look at from page 22 to 23, there's paragraph 22, and you go through 23, is that the environmental, risks or impact was assessed, and then based on that, that there was no significant risk posed to the environment, and there was no environmental financial I would say set aside that was made to be able to look at the rehabilitation of the facility going forward. If two parties are entering into a commercial arrangement, they need to take into account all liabilities assets and liabilities and do the proper due diligence to be able to finalize the transaction. And it is with that understanding that this was looked into. Normally, we would then have, as a regulator, come in and pose certain questions with regard to that, so that you don't get the risk of a situation where there is environmental risk that is unduly passed over to the buyer without that buyer being able to discount that in terms of the price. If people knowingly go into that kind of a transaction, it is then the risk that they take upon themselves. But that liability will not go away in any event. But it is clear here, and it was my understanding, because I had looked at this prior to it coming here, and that if the issues of set asides for rehabilitation will then have to be looked into going forward in terms of what is in the tariff that AXA then will have to apply for. That was my understanding. Thank you.
Thank you, Mr. Mkhize. I think Ms. Mtwa's hand is down, and I assume he wanted to also come in on that note.
Sorry, Chair, I'm just coming in here because I think that the way the team is responding is actually bringing more confusion than actually being able to just come forward and be straight that the risk that is posed here is minimal, if any, and that then there was no, there are no implications really when it comes to rehabilitation funds per se. But it is a matter that we constantly look into and enforce where possible. Thank you, or applicable.
Thank you, Mr. Mkhize. I think maybe it's just the enhancements of that paragraph such that it does indicate those environmental liabilities that have been agreed to between the two parties, so that we, when we read the submission, it indicates that these environmental liabilities includes, amongst others, issues relating to the rehabilitation of land. We in terms of our regulatory tools or framework, if we elaborate on that, it will make it easy for the reader to be satisfied that it covers that. Any other point, members? Ms. Masetti, your hand was up. Are you covered? I would assume that we are covered, and colleagues, I think it's just a matter of writing skills in terms of how we can ensure that a reader who was not part of the analysis really can get an understanding of what it needs to be covered or what's being said with the submission. So it's just a point of enhancing that paragraph 24 to ensure that the environmental issues or liabilities that are mentioned there are actually linked to our regulatory tools that we have. On that note, I would assume that that we are covered. And let me just go. I saw one of the questions in the chat, and let me just see. Okay, there is Ms. Masetti. I don't know, Ms. Mtwa, if you want to respond to that last point raised by Ms. Masetti before we go on to the recommendation on paragraph 5. I think basically it comes to the point that I was making, that our compliance with some of the regulatory tools and other pieces of legislation, we need to really clearly write them in a manner that a reader who is not part of NESA or part of our processes can read and be able to understand what is being said or what needs to be covered in the submission. On that note, members, may I request that I take you to page 5, paragraph 14.1, and I think Mr. Ndawana did read the recommendations into the record. Maybe just to repeat them, is that the REC is requested to consider and approve the revocation of a license issued to BP Southern Africa Limited for the operation of a petroleum facility located at the Platten Bay Airport, Western Cape. And also there is the decision and reasons for decision that are attached as an extra one, and also to note the request of the members in terms of really enhancing the submission to provide much more clarity on issues that relates to our regulatory tools that we need to comply with. On that note, members, can I get an indication that you support the recommendations under 4.1 A and B, and the addition that is for a need to really be clear in the submissions or recommendations or submission? Thank you, Ms. Masetti. Thank you, Mr. Mkhize. I also support the approval of the recommendation and the noting of the need to enhance the submissions as directed by the members. We then move on to the second item, that is for the open meeting on petroleum pipelines regulation, which is item 8, which is the BP Southern Africa application for the revocation of a license issued for the operation of a petroleum storage facility located at the Rand Airport, Germiston in Gauteng. Ms. Mtwa, if you can guide us on the presenter and as well as in the presenter for this particular item. Over to you.
Yes, thanks, Chair. Also, this presentation will be done by one of our learners, Ms. Lerato Moloi. Please go ahead. Thank you.
Good morning, Chair, members and colleagues, and also members of the public. Thank you for the opportunity. The submission is taken as follows. BP applied for a revocation application to the Energy Regulator for the operation of the petroleum storage facility located in Germiston, Gauteng Province. The application was made in terms of Section 24, subsection 1C of the Petroleum Pipeline Act, which states that the authority may revoke a license on an application of a licensee if another person is willing and able to resume the rights and the obligation of the license. As such, BP submitted a declaration from Rand Airport Holdings stating that they are willing and able to resume the rights and the obligation of the license. In addition, BP also submitted an environmental assessment report indicating that there is no environmental liability that will disadvantage the new owner of the storage facility. In terms of the market consideration, there will be no storage capacity lost as the new owner will resume the operation of the facility. With all the information provided, I recommend that the Executive Committee to grant BP their revocation for their facility located in Germiston, Gauteng Province, because they met all the requirements in accordance to the Pipeline Act, and that the revocation itself will not have a negative impact on the energy sector. Thank you.
Thank you very much, Ms. Moloi. Members, any questions, issues of clarity, or points of enhancements for the team? Over to you by show of hand. Thank you. I see Ms. Masetti's hand is up. You may come in, ma'am.
Thank you, Chairperson. Chairperson, I would like to suggest that we remove that statement that says that BP has met all the requirements. It is not true. It has not met the requirement on the on making sure that there is a provision for land rehabilitation. It is in terms of the regulation. So that's number one. And NERSA has a duty to make sure that the operation of the infrastructure is done in a manner that environment. It is in terms of our act. Hence, we also have that requirement in the regulations. That is the second point on this. Then the fact that the licensee is aware that it should have, or there is that requirement for land rehabilitation. The fact that the licensee is making a submission for us to consider, to say that from its assessment, there is no risk of an environmental, an environmental harm It is something that obviously from our side we did not have sufficient time to really check whether that could be the position or not. So that's one thing, but we can note that's one thing, but it doesn't mean that they have met with the requirements of the law. So we can't make that statement. And the last point that I would like to make about this is that, if the infrastructure has been operated, say, for 10 years or so, the fact that we are also required at the time, assuming that there's somebody else who's going to take charge of these resources or this infrastructure. Now that person will have a catch-up to do in terms of the what may be required should that person at some point want to revoke or what you call demolish the or cease to operate the facilities. So hence we always look at whether the allowance that is put for decommissioning will be sufficient and kept up with inflation. It is those kind of things. So let us not say then that BPSA has complied fully with all, because it is not factually correct. That's the point that I want to make, Chairperson. It is one thing for the person who makes an application to argue that there is no environmental concerns if for the person who's going to take over and continue with the operations. That might fit the circumstances of the decision that we want to make now. However, there will be that, the gap in terms of the fact that there was no allowance for decommissioning that was done at the time, and that might affect the sufficiency of the allowance should there be rehabilitation of land or need for rehabilitation of land in the future. That's just the disadvantage. Thanks, Chair.
Thanks, Ms. Masetti. Any other point, colleagues, that you may have on this particular application, members? If none, I'll allow the team to then come in and respond to the point raised by Ms. Masetti. PPR team, Ms. Mutwa, you can guide us who's going to respond. Thank you. I see there's a hand from Tate Untit. You may come in, and Tate Untit.
Thank you, Chair. The comments on the previous matter, which is similar, but with specific different situation in terms of the specific runway issues, which doesn't apply here, is that if I can't read the number, but in paragraph 3.1. The current asset value is shown, and that read together with the report from a external service provider that has been appointed. So the NEMA Act says that the applicant can't do it itself; it needs to use an external accredited party. So that party is accredited. They've submitted previous reports too for different licensees, and therefore on that basis they also indicated there was no risk, and there wasn't a need to trigger an EIA. So the competent authority remains the NEMA regulator, but as discussed in the previous matter also, and again raised now, there is certain requirements that NERSA also has to enforce. But I'm not sure if I've replied sufficiently to then the question, but there wasn't a EIA triggered or the need for such based on the accredited service providers' reports.
Okay, you mentioned 3.1, Martin. I was a bit lost there because 3.1 talks to the authorities in the submission cover, and when I go to the main submission, there is the reasons for decision. There's no 3.1. Can you just direct me? Maybe didn't hear the numbering that you mentioned correctly.
No, Chair, maybe I could have done it more elegantly. It does just show the number. The number itself is not reflected in the RFD section, but I wanted to give a sense of what the assets amount to, in terms of the cost, what is involved there. So it's not
okay.
Sorry for confusing you.
No, that's fine. I've noted it now. Members, thanks, Dr. Untit. Members, any questions, issues of clarity or points of enhancements for the team on this particular application? I see Mr. Mkiza's hand is up. You may come in, sir.
Thank you, Chairperson. I think when it comes to this whole issue of land rehabilitation, which goes with the environmental risk, I think the team, through the Chairperson, then a request that the team looks at, holistically looks at how the issue of land rehabilitation is going to be factored in when there are revocations and new owners coming into play. Because it's one thing to deal with it
I think we have lost Mr. Mkiza. I don't know if it's me that can't hear him. I can't hear him.
No, we've also lost him, man.
Can you now hear me?
Yes, we can hear you now. Okay. You may proceed from when you were asking the team to try and do something.
I was saying that we're going to try to I'm asking the team that they look at this whole issue of rehabilitation holistically, and then be able to maybe as an action item to say this is how it's going to be addressed going forward. Because to deal with on a case-by-case basis could not be assisting much in terms of the understanding, common understanding from by all concerned. By way of saying, for example, there will be situations where there is no environmental risk that is seen by an independent consultant in the space to say then that there's no risk that can be carried through to the new owner. And also, we don't want a situation where the new owner has taken over a facility that for whatever reason, might not have factored in the environmental liability. To be able to have those check points, to say that checklist that says, have you considered environmental risk? What are the implications? Also don't want a situation where somehow the risk is passed over and discounted, but not no funds put the new owner buying a site that is risky in terms of the liability, but the price is lowered, if you get what I mean. So we don't want to make sure that from our side, in terms of doing what we're supposed to do, in terms of looking at the catering for the funds for rehabilitation is done accordingly, noting that the Department of Fisheries and Forestry, as well as the Environment, is the one that is tasked with actually the administration of NEMA. And on our side, we come as a sector regulator, as an economic regulator, to look at the provision of funds to actually effect the rehabilitation itself. Thank you.
Thank you, Mr. Mkiza. Any other point? I think based on what Mr. Mkiza is saying to the PPR team, I think there may be a need for us to improve the paragraph on environmental consideration. such that that particular paragraph also covers the relevant pieces of legislation and as well as our regulatory tools, particularly the requirements on the rehabilitation requirements. Maybe we could improve that paragraph 21 to 23 to cover that, such that we do not raise issues of rehabilitation. So I hear Mr. Mkize suggesting that we really come up with a position to do that, but I would want to also add to say that in each and every submission similar to this, let's just enhance those paragraphs to cover that particular issue on our requirements in terms of the regulations for rehabilitation. We really clarified in there. On that note, I do not see any other hand. Members, I would like to take you to the recommendations that Ms. Moloi has already read into the record, but I will try and repeat them. Again, the recommendations are on page 5, paragraph 14, and the recommendations are that the revocation of a license by BP Southern Africa Limited, Pty Limited, for the operation of a petroleum facility located at the Rand Airport, Germiston, Gauteng Province, and also to approve the decisions and reasons for decisions that are attached as Annexure 1, and also to note those improvements that members have raised to ensure that we enhance these type of submissions. Thank you, Ms. Masetti. I also support the approval and the noting. Thank you, Mr. Mkize. Ms. Mtwa, the submission is approved, and there are those notings, noting factors that needs to be taken into account in future similar application. We move on to the next item that was for our open session, which is item 9, and it is the decision and reasons for decision for the multi-year tariff application by SA Bulk Commodity Trading and Storage Facility Pty Limited for its petroleum storage in Germiston, Gauteng Province. Over to you, Ms. Mtwa, for guidance and presentation of this particular item.
Thank you, Chair. I will allow Ms. Msomi to assist in the presenting of this tariff application. Thank you.
Thank you, Chair. Good morning, members, management, and the members of the public. The purpose of this submission is to request the RSC members to approve the tariff applied for by SA Bulk for its petroleum storage facility in Germiston for the period of 1 March 2024 to 28 February 2027, and approve the decisions and the reasons for decisions document attached here to as Annexure A. It should be noted that this is SA Bulk's first tariff application, and the energy regulator granted an operating license for SA Bulk on 17 September 2024. The assessment of the tariff application starts from page 9 of the decision and the reasons for decision. NERSA determined the following tariffs: 17.42 cents per litre for the 2024-2025 financial year, 17.38 cents per litre for 2025-2026 financial year, and 17.07 cents per litre for 2026-2027 financial year, which is approximately 1% lower than the tariff applied for by SA Bulk. The difference in tariffs calculated by NERSA and SA Bulk is mainly due to the difference in REP values, which arose from the application of different CPI rates, resulting in a difference in revenues calculation. It is therefore recommended that the RSC members approve the tariff applied for by SA Bulk for its petroleum storage facility in Germiston for the period of 1 March 2024 to 28 February 2027, and approve the decision and the reasons for decision document attached to as Annexure A. Thank you, Chair.
Thank you very much, Ms. Msomi. Members, any questions, issues of clarity, or points of enhancements that you may have in relation to this submission, please do come in. By show of hand, I'll recognize you. Over to you, members. I don't see any hand from any of the members. I take it that the submission is very clear for consideration by this particular committee. And I'll request that we go to the recommendations, which are on paragraph 14 on page 13. And the recommendation. Oh, Mr. Mkize, you may come in.
Now, just to stress one thing, that when I look at paragraph 4.3, that it then becomes very important for the team to ensure that where there is the storage of various products, including non-petroleum ones, that it becomes important for them to do verification from time to time in line with the monitoring and enforcement framework. Thank you.
Thank you for that point, paragraph 4.3, colleagues. In PPR, if you can note that and ensure that there is enhancements related to the contribution made by the member. We then go on to page 13, and that has the recommendations. The recommendations are that the REC is to approve the tariff applied for by SA Bulk for its petroleum storage facility in Germiston for the period 1 March 2024 to 28 February 2027. That is provided in table 6. And the tariff, therefore, is from 1 March to 2024 to 28 February 2025, which is at 17.56, and the next one of 1 March 2025 to 28 February 2026 is at 17.52, and the next one on of March 2026 to 2027 is at 17.24. So this is an application for those 3 years, and that the REC approves the decisions and reasons for decision attached here as Annexure A. By show of hand, members, can I get an indication that you support the recommendations with the enhancements made in terms of clarifying the provisions highlighted by Mr. Mkize? I see there's a hand from Mr. Mkize. I note the support for the approval. I also do. Ms. Masetti, I don't see Ms. Masetti. As indicated earlier on, she has some emergency that she's dealing with. I'm just hoping that she will be able to come back to us, but we do have a majority in support of this particular consideration and approval of item 9. So item 9 is duly approved. We then move on to the next item that was for the open session, which is item 10, and it's the SLG Pty Limited full year financial report for the period 1 July 2023 to the 30th of June 2024. Babu Nomalo, if you can guide us on who is going to lead the committee in considering this particular item that is for the open session, item 10 on SLG's submission of their regulatory financial report. Over to you, Babu.
Thank you, Chairperson, and good morning to members and colleagues. This one will be introduced by Mr. Ngobeni.
Thank you, Chair. Good morning to members and colleagues. The purpose of this submission is for the REC to approve SLG's full year regulatory financial reports for the period 1 July 2023 to 30 June 2024. The evaluation of the RFRs covered 4 key areas, which is the evaluation of the administrative procedures, the audit report, the comparison of the estimates versus the audited financial information, and the financial ratio analysis. Chair, the analysis of the administrative procedures as reflected in Annex A shows that SLG complied with all the administrative procedures as required in the RRM Volume 1 and 3. The audit report submitted by KPMG reflects that SLG's RFRs are fairly present in all material aspects, the financial information as at the period ending 30 June 2024. Chair, when comparing the projected versus the audited financial information, a potential payback to customers is reflected there, Chair. And this potential payback to customers will be scrutinized when SLG submits its next maximum gas price application. Chair, in terms of the financial ratios, they indicate that the overall financial performance of SLG is positive and that SLG is able to pay all its obligations when they fall due. Chair, the recommendations are on paragraph 14 on page 9. Thank you, Chair.
Thank you, Mr. Ngobeni, for the presentation. Members, any questions, issues of clarity that you want the team to respond to, or any points of enhancements for consideration of the team? Please do feel free to raise them. Members, anything? Mr. Mkhize? I see we may have lost Ms. Masetti. Ms. Jansen van Vuren, please let me know if you still have her in the meeting so that we are aware of her challenges. Please do. Mr. Mkhize, any comments?
Thank you, Chairperson. From my side, I would just say that I would appreciate if when it comes to the ratios, for example, to look at the liquidity ratio, how it has, changed. But you don't get a feel around it being compared to some kind of benchmark, industry standard, or a norm. I think it would help to get a view of the general state of health, not in comparison with itself, but to look at the comparison of the company with its peers, or some level that has been deemed acceptable, or good from a sustainability point of view of the entity. That would just be my take on this on these ratios that are presented before us. Thank you.
Thank you, Mr. Mkhize, for that. And I think it's not only the current ratio and all the others that are said to be the same. Maybe if you can just provide an indication as to what is the what is considered to be the acceptable levels, or even also to indicate where the licensee was in the previous financial year. On that note, I do not see any other hand members that is up. I would then, in the absence of those contributions for enhancements of the submission, request that we go on to the recommendations that are on page 9, paragraph 14, which are for the REC to approve the SLG's full year RFRs for the period starting 1 July 2023, excuse me, to the 30th of June 2024 that have been submitted in compliance with the requirements of the RRM's Volume 1 that is attached here to as Annexure C, and also to note the other relevant annexures to this particular submission. On that note, members, can I get an indication that you support the approval of this particular RFRs from Sasol Pty Limited, noting the points of enhancements raised by members by show of hand? I do support Mr. Mkhize. Thank you, Mr. Mkhize. I do not see Ms. Maseti. I'm assuming that she's still having challenges with her connectivity. On that note, members, this was the last item that was for the agenda for our open session of the meeting. I would like to thank the members of management and support staff for assisting us in considering the items that were for the open session, and also to thank our members of the public for having joined us to this REC meeting number 392. And on that note, I would like to declare the open session closed and thank everyone for their attendance. And I would like to ask IT to assist in terms of indicating to me that the streaming has been stopped so that we can proceed with other items on the agenda that are meant for a closed session.